Of the Child Protective Services. In 1899, the first juvenile courts were established in Cook County, Illinois. In 1915, Child Helping Organizations was incorporated as the Child Welfare League of America. Dr. C.C. Carson was selected as the first director of the new organization. In 1923, standards of the juvenile court practice and molds for the juvenile court laws had been developed and intermediately revised by joint committees appointed by the United States Children's Bureau and the Nation's Council of Crime and Delinquency. We have a need for changes in the juvenile court proceedings. So many children are being taken away by the Child Protective Services, and some people fall in the cracks of the system with little evidence and no due process of law in the juvenile court procedures. 300 welfare institution cases is time for changes. CAPTA, a federal and state grants that are given to each county to keep children in the foster care and adopted out. We must let our president and government know that we want change. Change is needed in this country. There's no need to just be taking children from innocent families. Although we do have child abuse in this country, but a lot of children fall in the cracks of the system, and a lot of parents who are poor, perhaps maybe innocent, need to have some kind of due process of law. We need to keep our children out of foster care and keep our families together.
Offender, if I wanted to go for the unification plan, and that way I could reunite with my children. I told them yes, and I submitted to the unification plan. Well, when I walked out of the courtroom, I talked to another attorney, and he told me that I had just submitted to a guilty plea. And I said, what do you mean I just submitted to a guilty plea? So then I decided to go down to the basement and look at my file, and I found out in the file, in the minute order, it said, submit to allegations, waive right to trial. So in other words, all the allegations become true. So then I submitted to a guilty plea. So then I really got upset at the fact that I submitted to guilt, not knowing what I was really submitting to, so they violated my rights. They entrapped me into a guilty plea. And I feel also that the double jeopardy part, when I was looking at, in the laws of the law library, in the double jeopardy part, it says that they can try us for the same crime because it's a civil juvenile court, so then double jeopardy does not stand. In other words, I was retried again for the same crime, and I was pronounced guilty. So I feel that they are entrapping a lot of innocent parents on this reunification plan, and they're entrapping them into a guilty plea. They should not entrap a mother on the unification plan and waive their rights to a trial and submitting to guilt without really explaining that they're doing that. And also we should have open courtrooms, not closed courtrooms. And then the law on double jeopardy, Code 31, should be changed. We should not be retried on a crime that we did not commit. And also on the petition, when the social workers write up allegations against the parent, they should be assisted by a lawyer. And also the past history criminal record should not be submitted. There should be some kind of seal against that to submit allegations against their past history. They should go with the present and not use things that are irrelevant to the case.
Reunification plan formulations and ordering of adequate reunification plan is mandatory. Initial depositions orders which remove minors from parents' custody and which are based on finding that minors are dependents and therefore subject to jurisdiction of the juvenile courts. In regards to Michael S. Act 4 District 1978, 234 Cal Report 84, 188 Cal App 3rd 1448, in the juvenile courts, a contract is given to the parent and asking the parent to accept the reunification plan in order to return children. Parents are not aware what the reunification plan truly means. Most of the time, parents are never explained. In the minute or in the parent's file, it states in small print, submit to allegations, waive right to trial. This law needs to be amended because the reunification plan takes away a parent's rights to a trial, and in order to follow the plan, all allegations, what the social worker said, become true. You are guilty with no due process. Hearsay evidence contained in a social worker's report is admissible in the juvenile dependency proceeding. In regards Christina H. Act 6 District 1996, 54 Cal Report 2nd, 722, 46 Cal App 4th, 1635 review denied. This law needs to be amended because hearsay should not be admissible in the juvenile courts. The juvenile courts need to produce more factual evidence for the best interest of the adult parents.